So we first would like to thank you all for allowing us this opportunity to provide an informational briefing concerning the United States-Mexico-Canada Agreement, also known as the USMCA. During this presentation, we'll provide information regarding background and overview and introduction of the USMCA Center, entry procedures, the USMCA resources that are available to you, and finally, we'll open the discussion up for a question and answer session. Again, we thank you all for joining today, and we'd like to go over the objectives of this presentation. So the main objective is to present an overview of the U.S. Customs and Border Protection, Office of Trade's efforts to implement USMCA, as well as answer questions and share resources to help support the trade industry members in complying with USMCA requirements. Next, we'll talk about the USMCA background and overview. So the general purpose was to provide provisions that modernize existing provisions of NAFTA. The new USMCA agreement does feature new and novel provisions related to automotive goods. Key provisions of the USMCA include increased regional value content, commonly referred to as the RVC. And as we transition from NAFTA to the USMCA, eventually it will go from 62.5% to 75%. Labor value content is also provides a major change from NAFTA to the USMCA. Under the USMCA, importers must certify that a certain percentage of the automobile's content by value is sourced from manufacturing facilities in the US, Mexico, and Canada that pay at least $16 US. This provision is new. It wasn't introduced in NAFTA, and USMCA seeks to implement this provision. The additional provision for automotives is in the area of steel and aluminum requirements. Importers must certify that at least 70% of the vehicles producers' overall annual purchases of steel and aluminum by value are sourced from North America. Currently, CBP is working closely with our government partners in Canada and Mexico and the trade community to ensure a comprehensive and smooth implementation from NAFTA to the USMCA. And as you all are aware, the USMCA was entered into force on July 1st of this year. So next we'll talk about general provisions of the USMCA. That include the agreement name, implementation date, expiration period, merchandise processing fees, post-importation preference claims, the general notes, Code of Federal Regulations, also known as CFR, and special program indicators. So as we previously mentioned, the name of the agreement is the USMCA, is the short acronym. It can also be referred to as CUSMA. When we reach the final agreement, each nation sort of put their nation ahead of the other two nations. So in Canada, it would be CUSMA, and in Mexico, it would be TMEC, so to speak. As previously stated, it was implemented on July 1st of 2020, and it includes a sunset provision that requires a renewal consideration every 6 years and a final sunset clause of within 16 years. So all three parties must come together every 6 years and come to a sort of common ground to continue the USMCA. Within the 16th year, they can decide to forego the USMCA, which is highly unlikely, but it is possible with the 16-year sunset clause. A major change is for merchandise processing fees. Originating goods and tariff preference level goods are exempt if the claim for preferential tariff treatment is made at the time of entry. And we want to stress that it has to be made at the time of entry. We'll discuss this in further detail as the presentation proceeds. Post-importation preference claims for the USMCA allows post-importation preference claims to request a refund of excess duties within 1 year of importation in accordance with 19 USC 1520 D as in Delta. However, MPF paid on entries are not refunded. And USC stands for US Code. And if at any point in time I provide an acronym without providing what it means first, please stop me, because we want to ensure that you all have the greatest understanding of this information. And we do understand that we may talk with our common vernacular using these acronyms. So next we'll talk about the citations. A major citation that provides insight for the USMCA is General Note 11. General Note 11 can be found on usitc.gov, and that provides a wealth of information regarding rules of origin, tariff treatment, and things of that nature. The CFR, which stands for Code of Federal Regulations, the U.S. Code citation is to be determined, but the USMCA will be reflected in 19 Code of Federal Regulations, Section 182. It's currently available and it is continuing to be developed. The Special Program Indicator, also known as an SPI. Tariff items eligible for preferential tariff treatment under the USMCA will leverage a new Special Program Indicator of S as in Sierra or S as in Sam that will be reflected in the special column of the Harmonized Tariff Schedule of the United States. That Harmonized Tariff Schedule of the United States can also be found at the US ITC website as well. CBP will continue to keep the trade industry apprised of additional information as it becomes available. So next, I would like to introduce you all to the USMCA Center. Currently, we have Tamika Solomon, who is the acting director of the USMCA Center. Adam Selesky is the branch chief of the USMCA Center. And we work in close coordination with offices within CBP because the USMCA, implementing the USMCA, requires a monumental effort. And so we wanted to highlight some of the offices or personnel that assist us in implementing the USMCA. And those individuals include Director Maya Kamara. She provides a wealth of knowledge. It is a resource to the center. And she is the Director of Textile and Trade Agreements Directorate within the CBP Office of Trade. She directs 3 individuals, and they have been, they provide additional support, and they are her branch chiefs. So Margaret Gray, also known as Maggie Gray, she is the branch chief for Trade Agreements Branch, CBP, within the CBP Office of Trade, TTAD. Also, we have Anita Harris. She's the branch chief concerning textile policy. And finally, we have Jacqueline Sprungle, who is the branch chief of enforcement. And they make up the the head, so to speak, of the Textile and Trade Agreements Directorate. My screen just flashed. Are you all still able to see my screen?
Yes. Yes. We can still see your screen.
Okay, for some reason my screen went black. Okay, apologies.
You're fine. The screen did go black just now. I think we lost him. Maybe.
While he's working on the screen, I'll continue. My name is Tamika Solomon. I'm the acting director for the USMCA Center. And I'll just go ahead and talk a little bit about the USMCA Center. Customs and Border Protection is the United States lead implementing agency with respects to the USMCA. And to this end, CBP has launched the USMCA Center, which will ensure, coordinate, and guide the implementation of the USMCA for our internal CBP stakeholders, as well as the trade community and you guys, our external stakeholders. The USMCA Center is your one-stop shop for all things USMCA. The USMCA Center will coordinate CBP's implementation and enforcement of the USMCA to ensure a smooth transition with consistent and comprehensive guidance. Organizationally, we are housed within the CBP's Office of Trade, and our USMCA Center includes subject matter experts from across all of CBP's offices and centers of excellence and expertise. Our staff is made up of auditors, attorneys, national entry, and import specialists, just to name a few of the experts that we have within our center. We launched our center in March of 2020, and our center is expected to operate for the next 3 to 5 years. The purpose of our center is to track, promote, and enforce some of the efforts that's going to be coming up with the USMCA. We have 3 core responsibilities, and those responsibilities are coordination, communication, as well as regulations and policy. And as our center evolves over time, we're going to continue to build upon those 3 guiding responsibilities. CBP will continue to communicate throughout the implementation process, and we're going to help everyone transition from NAFTA to the USMCA. We are your center, so whatever you need, we're asking that you check with us first because we have tons of resources. Another thing that I want to kind of hit on during this presentation is the fact that we've provided a number of different regulations recently. We were able to provide some implementing instructions. And in those implementing instructions, we talk about a lot of important items. Some things, as Daniel mentioned when he was presenting, is the changes. It highlights those changes with the regional value content, the labor value content, and it also talks a lot about the rules of origin, especially the fact that we no longer need a form necessarily, but now we're transitioning to more of focus on having those specific data elements involved. So that I want to point out that those implementing instructions is a very good resource and document to help you make that transition from the NAFTA into the USMCA. So that was a little bit about our center and what we're aiming to do. The next part of the presentation, we're going to talk about entry procedures and the requirements. Can we go to that particular slide? Yes.
This is Mary Alice Nowak. I believe Daniel is having some technical difficulties, so I am also a detailee to the USMCA Center, and I am going to take over from here. So as Director Solomon said, we are going to just briefly be discussing entry procedures and requirements pursuant to the USMCA this morning. Specifically, these are the topics I'll be covering in the next little while. As you can see, making a claim. I'm going to be addressing merchandise processing fees, reconciliation and drawback claims pursuant to USMCA. I'm going to touch a little bit on country of origin marking, post-importation claims under USMCA, and I'll be discussing the concept of de minimis, as well as the treatment of sets, and also a little bit on transit and transshipment of goods under USMCA. So if we can move on to the next slide, please. Okay, so as far as general information, as far as making a claim under USMCA, as I believe Daniel already mentioned, the SPI, or Special Program Indicator for USMCA, is S as in Sam, S as in Sierra, whichever you prefer. And this is reflected in the Harmonized Tariff Schedule of the United States, where you will see this SPI listed in the special sub-column in column 1 of the Harmonized Tariff Classification. And so when an importer files a claim using this SPI of S, he is certifying that the good complies with this rule of origin, as well as all record-keeping requirements. And he still must use reasonable care when making that claim. All of that is still in place as it was under NAFTA. Something else to keep in mind: USMCA may also be claimed on unconditionally free goods in order to receive an exemption from merchandise processing fees. Although in that case, the S will not appear in the special subcolumn of the tariff, but you would still need to claim USMCA by using SPI-S along with the tariff number of the good when you file that entry summary. This was also the case under NAFTA, so no change to that there, but I did want to point that out. In addition, SPI of S plus is also available for some agricultural products that are subject to quota, as well as some textile goods that are subject to tariff preference level claims. And the updated tariff schedule provides greater clarity on when you can claim SPI S plus in these circumstances. Okay, if we can move on to the next slide, please. Okay, so as you can see here, for most entry types, the date of entry or withdrawal for consumption determines whether NAFTA or USMCA applies. USMCA has been in force for about a month now, so this information becomes a little less important, but I did want to point that out. So if the entry date was prior to July 1st, which was prior to the USMCA's entry into force date, NAFTA did apply to those entries, and for July 1st and onward, USMCA is now the only valid claim that can be made for new entries. Also, there are a few entry types that require some special handling under USMCA. namely reconciliation and drawback entries, and I will be touching a little bit on these types of entries a little later on in this presentation. But I do want to point out here that entry type 8, which is NAFTA duty deferral, continues to exist unchanged as USMCA duty deferral, also under entry type 8. Okay, next slide, please. Okay, next I wanted to talk a little bit about merchandise processing fees. So in order to receive an exemption from MPF, claims on originating goods and tariff preference level goods for textiles as well, these claims must be made at the time of entry. The single window has been programmed to accept USMCA claims. All necessary ACE programming is now in place. But here's an important point to note, and that is that currently USMCA does not permit refunds of merchandise processing fees on post-importation claims. We believe this was a legislative error that occurred when the Implementation Act was negotiated and implemented. We have notified Congress of this error. They're looking into correcting it. However, we don't have any information at this point on when this will occur or whether it will be retroactive. But we will, of course, share any information on this issue with the trade as soon as it becomes available. Next, if we can move on to the next slide. So reconciliation, entry type 9 processing. So starting as of July 1st of this year, importers are able to flag an entry summary at the time it's filed for the possibility of making a post-importation claim for USMCA. Reconciliation entries are not mandatory, but once an entry is flagged for reconciliation, it becomes the exclusive means to file a post-importation USMCA claim. Okay, and you can see toward the bottom of this slide two scenarios when both a NAFTA and a USMCA claim are applicable after the USMCA's entry into force. So as far as entry summary X, which you see on the left side of your screen, the date of the importation of this entry was June 20th, so prior to USMCA entry into force. This entry is flagged for a possible NAFTA claim on June 30th, again, prior to entry into force. Next year, June 19th of 2021, this importer filed a reconciliation entry type 9 claiming NAFTA. This is all well and valid. On the right side of your screen, you can see in contrast, entry summary Y, date of importation July 2nd, so after USMCA's entry into force. This entry was flagged for a possible USMCA reconciliation claim on July 12th, so 10 days after, 12 days after USMCA entered into force. On July 11th of next year, the importer files a reconciliation entry claiming USMCA, also valid. Okay, so that is just an example to illustrate what we're talking about here. However, further questions regarding reconciliation should be sent to our colleagues over in reconciliation at OT, that's Office of Trade -recon folder at cbp.dhs.gov. Okay, so moving on now to the next slide. Okay, drawback. I do need to mention that USMCA retains the drawback restrictions that existed under NAFTA, but there are 5 key changes which we have listed below on this slide regarding substitution standards, the sugar exception, conditions of export, the ACE indicator for drawback, and finally, there are some changes to drawback claims for Section 201 and or 301 duties. And again, just like recon, as you can see on the bottom of your slide here, if you do have questions regarding drawback processing, you can send them to our colleagues who work drawback, and that email address, as you can see, is otdrawback@cbp.gov. Okay, if we can move on. So just basically a summary of these changes from NAFTA to USMCA with respect to drawback. Substitution standards. Okay, so USMCA does adopt Trade Facilitation and Trade Enforcement Act, or TFTA, substitution standards when drawback is permitted. So what we mean by that is that substitution will be permitted under the same 8-digit HTS subheading rather than this concept of same kind and quality substitution. Sugar exception. USMCA expands the scope of the sugar exception, which does retain the substantial transformation substitution standards. So again, the pre-TFTA substitution standards of same kind and quality for specific sugar products. As far as conditions of export, USMCA removed a NAFTA provision that applied a fee pursuant to Section 22 of the U.S. Agricultural Adjustment Act. And if we can move on to the next slide. As far as the remaining considerations, as far as the ACE indicator for drawback, for entries that are relevant for drawback under USMCA, CBP has created an ACE indicator, or a checkbox, that is added at the claim level to handle drawback. And we do expect the sunset for these drawback entries will be at least 5 years after the USMCA entered into force. And finally, as far as drawback claims for Section 201 and 301 duties, there is no change to this area. As with NAFTA, drawback filers for USMCA can submit claims related to these duties. And for more information on that, we would refer you to the Cargo Systems Messaging Service, or CSMS, message 19-000050. Okay, if we can move on to the next slide now. This just provides a little bit more information, a little chart for you to help you determine whether NAFTA or USMCA would apply. I am not going to go through this chart in detail, but we have different hypothetical dates, and you can follow along to determine whether NAFTA or USMCA drawback would apply to your entry. But I do want to call attention to that little box you see on the bottom of this slide, and just point out that an import dated 6/30 of 2020 and an import date dated 7/1 of 2020 will not be allowed on the same drawback claim, because USMCA entered into force on July 1st of 2020. In such a case as this, the claimant would need to file 2 separate claims for NAFTA and USMCA with the respective consumption entry date. So again, it is the entry for consumption date that governs whether NAFTA or USMCA drawback will apply, but those claims cannot be filed on the same drawback entry. Okay, so if we can move on to the next slide. Okay, next I just wanted to talk a little bit about country of origin. So as far as changes from NAFTA, the rules of origin contained in 19 CFR 102 continue to determine the country of origin for marking purposes of a good imported from Canada or Mexico. This is the same under NAFTA, and again, for most goods, only those product-specific rules of origin contained in General Note 11 of the Harmonized Tariff Schedule will be needed to determine whether the goods are originating. However, as far as changes from NAFTA, a good no longer needs to be marked or to qualify to be marked as a good of Canada or Mexico.
I think you cut out just now.
In order to receive U.S. certain agricultural goods, as you see here. How much of my presentation did you miss?
Just for a short few seconds, if you could just repeat what you were saying just a few seconds ago.
Okay, I'll pick it up at changes under NAFTA, because I do need to point out these changes from NAFTA. Unlike NAFTA, a good for which USMCA is claimed no longer needs to qualify to be marked as a good of Canada or Mexico in order to receive that preferential tariff treatment, with the exception of some agricultural goods. But in addition to that, a good with, we call it here a non-foreign origin, but what we mean here is a U.S. good. This is now under USMCA. U.S. goods are eligible for preferential tariff treatment, and U.S. will also be accepted as a country of origin on a USMCA claim. That is a significant change from NAFTA, which did not allow NAFTA claims to be made on U.S. goods returning to the United States. So I just wanted to make sure everyone was clear on that. If we can move on to the next slide then. And I'm just going to talk a little bit about post-importation claims. USMCA does allow importers to file such claims to request a refund of excess duties paid on goods pursuant to 19 U.S.C. 1520D. Again, just as under NAFTA, post-summary corrections or PSCs are not allowed on USMCA claims. However, I do need to point out once again, we are authorized at this point to refund excess duties paid on post-importation claims. We are prohibited at this point due to the legislative language from refunding MPF as of now. Again, we are working with Congress to address what we believe was an error in the drafting of the law, but we are prohibited right now from refunding MPF on such claims. However, except for that, in general, there is no change in requirements for post-importation claims between NAFTA and USMCA with regard to the effective period. They are still allowed for 1 year after the date of importation of the good. Responsible party, importer, that is the same. Eligibility, of course, the good needs to qualify for preferential tariff treatment. And such post-importation claims, whether they're submitted individually or through the ACE reconciliation prototype, need to include the information that you see here on your screen. A declaration that the good qualifies, a certification of origin, whereas under NAFTA that certificate of origin form was required, USMCA still does require a certification. A statement whether the documentation was provided to any other persons, as well as a statement on whether a protest or petition on that good had been filed. Again, all these requirements are the same as under NAFTA, but I did want to point that out as well. Okay, next slide. I think we have a little bit more information on post-importation claims. As far as decisions that CBP makes on these claims, we can deny such claims with a statement that specifies the deficiencies in the claim if any of the following that you see here applies. If the certification of origin is illegible, incomplete, if it contains incorrect information, or if the claim otherwise does not comply with requirements. However, post-importation claim corrections are allowed unless the claim has already been reviewed and decided upon by CBP. And we will accept such corrections up to that 1 year expiration period for the claim. Okay, next slide, please. Okay, couple more points with regard to USMCA provisions. There is a de minimis provision in USMCA, just as there was under NAFTA, and this de minimis provision now allows the good to qualify as originating if it contains no more than 10% of non-originating materials, including those subject to regional value content requirements. This is a bit of a liberalization under, as opposed to NAFTA, which you may recall the de minimis threshold in that case was only 7%. So USMCA does liberalize this just a bit. And again, this is now not to exceed 10% of either the transaction value of the good or the total cost of the good. And then as far as RVC requirements, if the good is subject to RVC requirements, the value of materials considered to be de minimis is included in the total value of non-originating materials when you're calculating that RVC. However, goods that qualify for de minimis are not required to satisfy the RVC requirements, provided that the good satisfies all other applicable requirements in the rules of origin. Okay. Next slide, please. As far as treatment of sets, And you will see these, you will see this set out in the agreement itself as well as in General Note 11, but just to summarize, except as provided for in any product-specific rules of origin, goods, and this includes textile or apparel goods, so this is a bit of a change, that are put up in sets for retail sale and classified pursuant to GRI 3 are originating if each good in the set is originating and both the set and the individual goods within that set meet all other requirements. And you can see an example we've listed for you here is that pumpkin carving set. Or you also have the option of originating that good if the total value of the non-originating goods within that set does not exceed 10% of the value of the entire set. And again, provided the good meets all other applicable requirements. So I just wanted to mention that. And if we can now move on to the next slide. As far as transit and transshipment, there are no real changes to these provisions under USMCA. They're essentially the same as they were under NAFTA, but I did want to point this out as well. So an originating good under USMCA will retain that originating status if the good is transported to the United States without passing through the territory of a non-party. So Canada to the United States, Mexico to the United States. If that good is transported outside the territories of the parties, the good may still retain its originating status provided that it remains under customs control in the territory of the non-party and it does not undergo an operation outside the territories of the parties other than the ones you see listed here. Unloading, reloading, separation of a shipment, storing it, labeling or marking the goods, or any other operation that would be necessary to preserve the good in good condition or transport it to the territory of the importing party. Okay. I believe that is all I have. If you can move on to the next slide. And I believe Daniel is back up and running again. So Daniel, if you can confirm that, I will turn it back over to you to discuss USMCA resources that we have available for the trade.
I am. Thank you, Mary Ellis, for
Thank you.
that information. We appreciate it. All right, so thank you all for your patience, and I'll be briefing the USMCA resources. So the USMCA Center seeks to connect the trade industry with information, resources, and tools to support the USMCA implementation process. All CBP resources cleared for public consumption are available on the USMCA webpage. You can see the URL provided below. We have broken up these resources, categorize these resources into 3 categories, which include informational briefings, written and multimedia materials, and additional U.S. government resources. The informational briefings provide USMCA overviews, including new and novel provisions delivered via trade associations and industry groups, such as the one that we are currently participating in now. Additionally, we have written and multimedia media materials, which provide compliance guidance, over 40 fact sheets, a side-by-side comparison of NAFTA and USMCA, points of contact, and frequently asked questions, as well as other resources. Additionally, we provide contacts for other government resources, links to the USMCA text, the Implementation Act, the International Trade. Sorry, I had a message pop up, but additional points of contacts as well as other resources. Next, we'll talk about USMCA, additional USMCA resources and on-demand training as well. So the Center published several compliance-focused resources on cbp.gov USMCA webpage for trade associations and industry groups to utilize. They provide an overview of the USMCA via a webinar video, as well as a topical USMCA provision guidance. Together, they provide information that allows the trade industry or trade stakeholders to understand the new and novel provisions while also highlighting key changes from NAFTA to the USMCA. They cover topics such as entry procedures, certification and verification, rules of origin, textiles, auto and automotive parts as well. Next, we'll discuss some USMCA foundational documents, which include the US-Mexico-Canada Agreement text, the U.S. Implementation Act, Public Law number 116-113, and USMCA regulations, which include the uniform regulations, the domestic regulations, and the HTS-US harmonized tariff schedule of the U.S. General Note 11. It is important to note that the Interim Implementation Act have several versions. So if you all do have questions, please include which version of the implementing instructions you all are submitting questions in regard to. Next, we'll talk about those final implementing instructions. And as you can see, the final implementing instructions were published on June 30th, 2020, and they support the trade to support implementation of the USMCA. It contains those contributions for the U.S. Department of Labor, Wage and Hour divisions regarding labor value content, and further expounds on how the necessary requirements to meet in order to be in compliance with the USMCA. Next, we'll talk about press releases and informational videos. So press releases and press engagements on the USMCA implementation was arranged by CBP Office of Public Affairs. Again, that's one of the offices that we have worked with, and they have provided a wealth of information that is available to the trade community. We've also developed informational videos and created up to 6 videos. I believe that 2 are currently available, and we're in the process of producing additional videos as well. As soon as they are available, they will be posted to cbb.gov and distributed widely to our trade stakeholders. Next, we'll talk about the fact sheets and the frequently asked questions. This is the quickest way to kind of gain an understanding and gauge some of the differences between NAFTA and the USMCA, as well as gain an overall understanding of the USMCA. So we have, again, 40 fact sheets that cover a wide range of topics, from chemical reaction rules. We saw that you all had some questions in regard to that submitted prior to this briefing. It also includes accumulation, treatment of textile sets that was previously briefed, fungible materials. So just a wealth of information available to you all within these 40 fact sheets. We also have frequently asked questions, and these questions basically cast a wide net to try to cover common topics, common issues that the trade community has, and those are available to you as well, and they can be accessed via the cbp.gov USMCA Center website. Next, we'll talk about binding rulings and the cargo system messaging system, also known as the CSMS. So in case that there are situations that require specific treatment, and they are unique to an organization, or it's a unique process, or a unique or it's unique merchandise, In those cases, we provide binding rulings and binding advance rulings and other legal decisions issued by CBP in connection with the importation of merchandise into the U.S., including other special trade programs like trade agreements and special trade legislations, can be accessed at cbp.gov/trade/rulings. These advanced rulings provide the trade community with a transparent and efficient means of understanding how CBP will treat a prospective import or carrier transaction. Essentially, what it does is it gives you all the greatest awareness and allows you all to, the trade community, excuse me, to import an item and know exactly how we will treat that item. And so it essentially allows compliance and also for preferential treatment, in cases of preferential treatment and duty classifications. It saves the industry time and money. And so that is one of our mandates, is that we facilitate the free trade of flow. And so submitting a request for a binding advance ruling serves all stakeholders. It serves the interests of all stakeholders. Additionally, we have the cargo system messaging service, and it is one of CBP's methods of communicating to our trade partners relating to news and updates on the automated commercial environment, also known as ACE. Additionally, we have additional resources which include the CBP Trace snapshot articles, CBP Information Center, and social media. We're on all of the platforms from Facebook to Instagram, Twitter, YouTube. We also have our CBP Information Center that you can literally call in and they will direct you or provide information or answer your questions in regard to CBP matters. The trade snapshot articles provide monthly articles which provide an overview of the latest updates on trade enforcement and facilitation milestones. It also highlights CBP's important trade programs, initiatives, and operations for our trade partners and the public. And you can bet your bottom dollar that we have articles pertaining to the USMCA as well. Additionally, we have, as previously mentioned, the U.S. government resources, the harmonized tariff schedule on the United States. I saw that that was one of the questions, and this is where you can find it, the usitc.gov, as well as the U.S. Trade Representative, USTR.gov, that provides a wealth of information as well. Federal Register notices can be one of your best friends. They highlight and provide insight into plans to implement trade agreements and a host of other issues within the trade. The USTR published a Federal Register notice on alternative staging regimes for automotive goods on April 21st, 2020. The U.S. Department of Labor has also issued a Federal Register notice for the new and novel labor value content as well. They also published an interim final rule relating to the labor value content requirements as well. The U.S. Department of Commerce is another excellent resource for exporter information, and we've provided that website address as well. And finally, we have the USMCA at cbp.dhs.gov inbox. If you all have any questions, we seek to answer all of your questions and provide the greatest insight and direction moving forward in this new USMCA environment.